Hi, I'm Sarah Borders with Benefits Compliance Solutions. Recently, we received the final 1557 non-discrimination regulations that basically have gone back and forth under many administrations. Now we received final rules as to how these are supposed to apply, specifically looking at group health plans. So, covered entities are required to comply with the 1557 rules. Essentially, covered entities are those entities that receive federal financial assistance and they are in the business of healthcare. So who is that? That usually means the carriers themselves. The carriers do receive, most of them, federal financial assistance. Maybe that's through Medicare reimbursements or other types of programs. And also the carriers typically have ASO arrangements to where they're not necessarily fully insured through that carrier, but they do run the claims and administer the claims much like they would if they were fully insured. So that pulls in a lot of self-funded plans as well. So essentially what this means is that covered entities are prohibited from refusing to treat an individual or otherwise discriminating against an individual on the basis of one of these protected classes: race, color, national origin, sex, age, or disability. The sex determination is quite important here. It's based on sex characteristics, which include intersex traits, pregnancy or related conditions, sexual orientation, gender identity, and sex stereotypes. So essentially, those cannot be discriminated against as to benefits themselves, so treatments. So essentially what this is saying is that exclusions or outright denials of claims specifically related to these types of characteristics in this protected class could run afoul of these non-discrimination rules. And so what that means for both fully insured, but mostly for self-insured plans, because they have more wide freedom over the coverage of their specific plan, it generally means that they need to be very cautious and should engage legal counsel if they want to exclude something like treatment for gender dysphoria or maybe any sort of surgery related to that typical type of treatment or that diagnosis. So those who want to exclude those types of benefits, they can rely upon a religious exemption, but again, they would want to work closely with their ERISA counsel to make sure that they don't run afoul of these rules or that they're just applying a blanket exclusion that would run afoul of these rules. These rules are highly litigious. We expect them to go through the courts. Again, pieces already have, and individuals to complain to HHS because they feel discriminated against. So you'll want to have this very carefully buttoned up, especially if you're self-funded and you want to exclude certain conditions or treatments for certain conditions. It's going to be something you really have to take more of a closer look at rather than us just telling you, yes, you can exclude them or no, you can't. So essentially, we're going to watch these rules very carefully. There's also some other notification requirements, especially as it relates to limited English proficiency included here. So please let us know if you have any questions. Thanks so much for watching.